Welcome to HOA Today, the video podcast for HOA board leaders. I'm Mark Foster on the HOA Leadership Network. Well, much to talk about regarding Senate File 1750, the Kiowa bill that seeks to reform HOAs and CICs in Minnesota with a lot of new restrictions placed on HOA leaders. It's cleared its final hurdle on Friday and is now headed to the floor of the state Senate. Here to discuss all of this today is Aaron Brooksby. He's an attorney with Smith, Jaden Johnson, SJJ Law, and one of our frequent speakers and visitors of our HOA Leadership Network chapters. Aaron, thanks for joining today.
Thanks for having me, Mark.
Well, let's talk about the committee meeting on Friday. I watched the replay. You watched it. This was the last stop before heading to the Minnesota State Senate. It was in the Committee for Judiciary and Public Safety. And Aaron, despite a lot of opposition by all the testifiers that were in there, it was a litany of testifiers with a lot of opposition to this bill, and also several senators who were opposed to it. The amendments did pass, and now it's headed on to the floor of the Senate.
That's right. We heard a lot of pushback from people testifying. There was a lot of pushback from people testifying. And then there were a fair amount of pushback, I thought at least, from senators on the committee. But at the end of it, it was pretty close to 5 o'clock, and they had the vote, and there were no nays. And so it made it through.
So what was interesting, I thought, so Senator Lucero, one of the authors of this legislation and the amendments, really made it pretty clear that he considers this to be a consumer protection bill, which is a very interesting label for this type of legislation. I don't think that's been really clear up until this particular committee meeting. Do you see it that way, and how do you sort of describe that action?
I can understand where he's coming from to try and say everything that they've said so far is that they're trying to put up guardrails to protect homeowners. Most other consumer protection issues are related to a consumer business relationship, and an HOA, I would say, is a little different from that. HOAs are fairly unique in that I don't think there's a really good way to describe what the legislators are trying to do without calling it a consumer protection bill. And so I think that by labeling it as that, and Senator Lucero was very clear this round to call it a consumer protection bill, I think that probably garners a lot of support from both sides of the aisle, because most people are pretty open to something that protects consumers. Now, an HOA, I don't think I would call homeowners consumers in an HOA. I would call them homeowners and members of an association. And so calling it a consumer protection bill, it makes sense why they're doing the things that they're doing to the legislation, why they're changing the law the way they're changing it, because they want it to be a consumer protection bill. An HOA is more like, it frankly is a nonprofit corporation. So they are treated like corporations, and they have been treated like corporations up till now with these bills. And so if it passes, HOAs are going to be more along the lines of a consumer relationship rather than a business relationship. And I think that's one of the things that homeowners have a hard time dealing with, is that you're part of a business and they want to be seen as a consumer. And so we'll see what happens.
Sort of interesting considering that throughout 2024, we were basically, as HOA properties, being treated as a corporation through the Corporate Transparency Act, the on again, off again, on again, now dead legislation. So it's kind of an interesting juxtaposition. So let's unpack this amendment that cleared this committee and is now headed off to the state Senate for debate. So it appeared that there was even some difficulty with some of the senators tracking the changes in the amendments compared, to the original bill itself. That was somewhat worrisome to me. But as we stand back and look at the amendments that did clear the committee, Aaron, what would you say are the top issues that you consider to be non-starters in this legislation?
They made a lot of changes, but a lot of them are technical changes. Some of the non-starters, they don't address the late fees, for example. That's one of the big issues that we've talked about, is capping late fees at $15. They didn't touch that at all. It's still $15. And so that, uh, frankly, I was slightly disappointed to see that that didn't change at all. Um, Other non-starters, they did a fair amount of work to make the changes they want to make clearer. They fleshed things out a bit, so that we can kind of better understand them. One of the things that I don't think we've talked a whole lot about, directly, um, one of the big things that is becoming a bigger issue, I thought they would address it, but they haven't really yet, is the relationship between management companies and homeowners associations. One of the senators, I think it was a senator, and there was some testimony about it as well, that want to move towards, if we're disclosing it, disclosure is more important than a complete prohibition. We should let the board members who are elected by their homeowners to be able to decide whether or not it's a conflict of interest. And as long as it's properly disclosed, they should be able to make that decision, because they're in the best position to make those decisions for their HOA. And the way it was written is just a complete prohibition on any type of conflict of interest. They've not watered it down, but they've just clarified things a little bit. And so it'll make it, if it passes, easier to work with. But one of the things they still haven't really addressed, is there's a cap on a $20,000 a year management fee. The way that the Senator Lucero talked about it, he said this section still needs a lot of work, which is a little confusing to me because they passed it through the committee anyway. But the way it's written, I think it would still prohibit most associations from being professionally managed, based on the caps that are in place. I think only very small associations would be able to be professionally managed under the law. That's not what Senator Lucero says it's intended to do, but that's one of the still, what I see as one of the main blockades in this legislation still. Um, that's concerning, because the choice of being able to choose to have your association professionally managed, the choice of what entities or what vendors you want to use, as long as there's proper disclosure, an association or a board of directors, I think, should have the option to make that decision. So that's one of the biggest issues that wasn't really addressed at all in these amendments.
Yes, and I think that going from 2,000 to 20,000 certainly is progress. And as you indicated, Senator Lucero indicated sort of a door open still on this issue. So presumably it'll get debated in the Senate, and potentially that will also be changed. But I think that the testifier from First Service Residential, one of the largest property managers in the state of Minnesota, who was at the meeting on Friday, expressed his dire concern that this type of approach could put property managers out of business.
Yeah, and I mean, a lot of the work that I do is I work kind of through a middleman of a board's property manager. Oftentimes I'll work directly with the board of directors, but sometimes I will work through their property manager, and so I'm aware of these relationships of my clients. I was doing the math on this and having an insight into what a lot of my clients pay for property management services. I think it would limit, the way it's written, at $20,000, even though that's a lot more reasonable than the $2,000 it was before. I still think there's a lot of property management companies who would just have to drop their clients, and so that's kind of a game changer in our practice.
That's right. I was going to say I would think there's a lot of large HOAs with lots of units that do need property management services and would likely exceed that $20,000 cap on an annual fee.
Yep.
Basis. There seemed to be other discussion around what HOAs can do with regard to legal fees and recouping legal fees. What's your take on all of that? That seemed to be a particular concern by several of the senators who are on that committee.
Yeah, and to give some insight, this was the Judiciary Committee, and so a lot of those senators are attorneys or were attorneys in their past lives or in their current lives, or when they're not being legislators, and so they understand kind of the legal system and how attorneys' fees work. And so there was some good pushback on that. Right now, these amendments kind of increased a little bit some of the attorneys' fees. One of the big issues that I brought up, I think we might have talked about this before. There's $1,000 cap on foreclosures for attorneys' fees. You could only assess back $1,000 of the attorney's fees. They've raised that in this amendment to $3,500, which is good. But they didn't address any of the other foreclosure issues. And so they seem to be making minor changes that appear reasonable and that are good. They're going in the right direction, but I think a lot of it just still, it's not enough to make a difference. It's enough to sound like you're making a difference, but the actual reality of what's going to happen based on this language, if it passes, I think we're still going to have some major issues that we'll have to deal with, and we're still going to see an increase in costs to all the homeowners rather than just the costs of enforcement being able to be assessed directly back to the violating homeowner.
Right. I mean, I feel like when you stitch together all of the testifiers, not only from this last committee meeting, but also the Senate hearing where I testified, the House hearing where you testified, and several others, it seems to be that the continued theme revolves around the fact that while the state legislators who are really in favor of this are trying to do something that will make affordable housing more affordable, it seems there are a lot of unintended consequences in this bill that could really drive costs up. Would you agree that that's likely the scenario if this bill passes in its current form?
I think it will. We've been trying to help educate and help point out natural consequences of the language that they're proposing to both the drafters and to other legislators. And a lot of the pushback that we get and have received, and that I know other people who have talked with their legislators have received, is, well, you're just jumping to the worst case scenario. That's not going to be the most common scenario. And in my opinion, I mean, I deal with this every day, and I think it will be an extremely common scenario where almost every HOA in the state is going to have to raise its dues to account for attorney's fees to pay for enforcement that right now we haven't, and previously we haven't had to budget for that because enforcement oftentimes falls on the specific homeowner that we're taking those actions against. And so that's a big one. There's a lot of other requirements that they're adding that I think most boards won't be well enough equipped to deal with on their own, that they're going to need an attorney to help explain or help draft required documentation and procedures. And so it might increase dues substantially next year, and we might see those costs go down a bit in the future. There's going to be like a one-time only type cost of making sure that we're complying. But overall, I think there is going to be a shift into having to pay out more, all of the homeowners paying out more because of these changes.
And it's coming at a terrible time. Most HOAs, if not all HOAs in Minnesota, are struggling with rising insurance costs, which have impacted monthly HOA fees to a very high degree, along with still, lingering inflationary pressures over the last, say, 4 years, which have created increases in labor costs and in material costs. So any kind of upgrades or any kind of projects that are on the docket in these HOAs are far more expensive. So this legislation, if passed in its current form, and certainly provides more pressure to raise fees. Again, that affordable housing, more affordable doctrine that seems to be touted by these legislators is simply not going to be true.
You're right. And that's one of my biggest concerns is they keep saying they're trying to make it more affordable to live in an HOA, but they're adding requirements so that the threshold, it's becoming more complicated and more complicated, and the only way to play in that world is to understand those complications and be able to address them, which inevitably will lead to, as much as I hate to say it, more attorney's fees. I think the HOAs are going to have to pay. there's a the way things have been working so far, there's procedures in place to deal with these things, and there's other remedies besides just starting a lawsuit.
Mhm.
The way that these changes are happening is I think we're going to see a lot more lawsuits. Um, which I mean, I'm an attorney. I get paid based on lawsuits, but I don't think that's the right option, or it's not the right direction. Lawsuits are a good tool. Right now, HOAs have a lot of other tools, and as much as they're trying to make it transparent and affordable, I think they're limiting the tools that the association has, which then it just defaults to a lawsuit. And I don't think that's the right direction that we want to be pursuing in an HOA.
Sure, lawsuits should always be the sort of the last measure, the final straw. And I think to your point, it could just become more and more common because of the way this is being put together. The other major concern we have at the network, and I know that you share this same concern, is given all of this complexity that you have wisely referenced, it is going to have what we call that chilling effect. It's already difficult to get any kind of residential involvement in board meetings at all, much less get them to become active on the board itself. This is likely to cause even a higher degree of chill and keep a lot of people away from ever volunteering. Do you agree?
I do. It's funny. I'm talking to one. I have one client right now who's dealing with a homeowner conflict, not enforcement of rules or anything. Just a home. There's a very opinionated homeowner in their community who has been abrasive to most other homeowners. Nobody wants him on the board. He's a retired attorney, and to be fair, a lot of the things he points out are technicalities that other people kind of gloss over, but he's correct. Um, and so the current board of directors is having a really hard time addressing this homeowner because he keeps pushing back and keeps pushing back, and this board is just getting burned out. They are, I mean, I'm working pretty closely with them, and they're doing things correctly by the book, and they get emails every couple of days from this homeowner disagreeing with their decisions, even though their decisions were done correctly, disagreeing with it. And I can tell that this board president, is on the brink of getting off the board. He's really not the kind of person who wants to deal with this, and he kind of stood up and took charge because there was nobody else to do that. And so that's a situation that we see often, where you get kind of board member burnout in having to deal with this type of homeowner that is trying to enforce their rights, but also just disagreeing with the board. And now, if this bill passes, that will, I guess, feed the fire of this type of homeowner. It'll give them an opportunity to essentially be part of the board. They'll get to speak up at board meetings and add their 2 cents to every board decision. And that's going to, I think, I understand it from a consumer protection perspective because we want to make things more transparent and give homeowners a remedy or a way to make their voices heard. But from the business perspective, where it's the board of directors, they're the only ones that have the authority to make this decision on behalf of the association, and they have a fiduciary duty to do it in good faith. I think I speak for a lot of board members where they say they feel a lot of burnout when they have to deal with these homeowners that are seeing things from a different perspective and not taking everything into account. And because that's going to become, if this bill passes, more homeowners will have a greater opportunity to do that. And it'll be more invasive on boards. And I think that's the legislators' intent. That's what they want, is they want homeowners to have a greater, more of a finger on the pulse of the HOA, which from their perspective is a good thing. From my perspective, where I deal with boards and the board members are the ones with the authority and the duty, those board members are going to feel burned out. And I think there's a lot of board members who are going to just say, okay, well, I'm done. I did my time on the board and I don't want to deal with this. And that's concerning.
Really, you're describing two different, possible bad scenarios, one of which is sort of board burnout and the burden of current boards that this legislation will certainly put upon them. And then there's the recruiting of new board members in the future, both of which might be stymied. Let's just talk briefly, Aaron, as we close out here. There was a companion bill introduced at the same time that the Senate bill was introduced. This one being in the House, it was bill, I believe it was 1268, if I remember the number. Haven't heard much about that bill of late. Has that lost all its momentum?
It seems like it has. I was doing some research on it because that was the one when it was introduced. It had a lot of momentum. That's where I went and testified at the House committee. Right now, if you look at the legislative status of it, it was kind of remanded to a prior committee, and it hasn't had anything happen in essentially since the beginning of March.
Okay.
So I don't know if that's because it's just lost all its steam. The House right now has its own share of problems with it being completely split, and so that might probably is affecting it. But one thing to remember is these two bills, when they were introduced, were identical. And so I think there would be, wherever the Senate bill ends up, I think there will be a lot of support on the House side to just adopt whatever the Senate finalizes. And so I don't know if it's really necessary for that 1268 to go the full way like the Senate bill is.
Yeah, I did notice that the author of the House bill, Senator Bonner, was in the Senate Judiciary and Public Safety Committee meeting on Friday. So that may send us the signal that confirms what you're talking about. So, Aaron, is it too late for concerned HOA board members, HOA residents who have been watching this legislation and have been, joining us at our rally last week at the Capitol and writing letters? Is it too late to continue to make noise and voice opposition to this bill?
It is not. And frankly, now is probably the best time, especially if you haven't yet, even if you have sent a letter or contacted your senator and your representative of where you live. Now I think is the perfect time, because the Senate bill has moved out of all the committees. It passed all the committees it needed to. It's now being addressed at the Senate floor, and now all of the senators in the state have a chance to vote on it, to review it and vote on it. And so right now is probably the best time to make your voice heard, to send a letter to your senator, send a letter to your representative as well, but to provide that information, share your experiences as a homeowner in an HOA, as a board leader. Talk about the things that are successful and pick out a couple of things in this bill that you think would be the most detrimental to your HOA and point those out to your senator. I think that's the best thing we can do right now.
That's really good advice. Well, we'll continue to monitor this. It's been an interesting couple of months, and it certainly is going through the paces very quickly. We'll keep an eye on it and keep reporting on it. Aaron Brooksby, thank you so much for joining us from SJJ Law Today.
Thanks, Mark. It was good to be here.
Thanks for joining us, everyone. Thanks for joining HOA Today. I'm Mark Foster, and this is the HOA Leadership Network.